All the other talking heads have no idea what they're talking about. Only our legal analyst, Greg Willard, knows what's going on. I don't believe anybody until he comes in and explains what the Supreme Court just did yesterday. Greg Willard, professor at St. Louis University Law School, as well as the KTUS legal analyst. Good morning, Greg Willard.
Good morning, McGraw.
First, let's start with the abortion ruling down in Texas. It was a 5-3 vote. Justice Ginsburg, in her opinion, in her majority, certainly lays out her opinion that under no circumstances, well, I was shocked at how forceful she was in her majority opinion.
She was. Hers was a concurring opinion, and I think it would be fair to describe it as an exclamation point on the court's holding. A couple of very interesting pieces to yesterday's decision. Number one, as you say, McGraw, it was 5-3. The fifth vote was Justice Kennedy, an appointee of President Reagan. Secondly, the opinion itself was written by Justice Breyer. Now that in and of itself is not unusual, but I think what's very telling is Justice Kennedy, as the senior justice in the majority, he had the right to decide who wrote the opinion, and he assigned the opinion to Justice Breyer. And it is a very powerful opinion, very exclamation point then by Justice Ginsburg's concurring opinion.
And basically they said what? What did the majority say about the rules that the state of Texas passed? It's got to be pretty bad that you overturn a state's elected officials' rules. I mean, that's kind of a big deal.
Well, it is a big deal, but that's part of our system, McGraw, that as Chief Justice Roberts at his confirmation hearing said, it's up to the Supreme Court to call balls and strikes. And so at the end of the day, in our system, it is the United States Supreme Court that decides the constitutionality of statute. What they decided yesterday was that the restrictions that Texas had placed on a woman's right to choose were undue burdens on that right and were therefore unconstitutional. Specifically, the state of Texas required that physicians who perform abortions had to have admitting privileges at a hospital. And number two, that the centers, the location at which they perform the abortion, had to meet certain ambulatory surgical center standards. What the court held was that the benefits to women's health from those laws were negligible. And they compared them to other medical procedures that did not require those standards. And secondly, they placed those limitations and the effect of those limitations placed an undue burden on a woman's right to choose, and therefore they were held to be unconstitutional. The fallout, I think, McGraw, will be significant. There are 31 states that have specific restrictions on abortions or abortion providers. 25 of those states have at least one of the two elements that Texas had, including Missouri. And 14 states have an outright ban on abortion at 20 weeks. So I think what we're going to see is a significant amount of litigation, including in Missouri, relying on this decision yesterday to invalidate other states' abortion legislation.
You're here to sort of explain it to the rest of us, and I know abortion is a very volatile topic, but if you are extremely pro-life out there, this is a very disappointing ruling, and one in which I would think if you're pro-life, you're asking yourself, where do we go from here if we want to try and overturn Roe versus Wade? Because this is another, is it not another affirmation of a woman's constitutional right to choose?
Very much so. Maybe we could take a step back, McGraw, as to how we got here constitutionally. For 180 years of our republic, it was settled law that the states would regulate abortions. In 1973, the United States Supreme Court, by a vote of 7-2, announced that a woman had a right to choose. She had a right to privacy. Critics say they just created it out of whole cloth. Others say they found it in the 14th Amendment. Whatever you want to characterize the basis of that ruling. The court in Roe v. Wade announced that a woman's right to privacy included the right to have an abortion. 20 years later, in Planned Parenthood versus Casey out of Pennsylvania, the court reaffirmed the right to choose, but went on to talk about viability of the fetus and pre-viability and post-viability.
When was that? When was that Planned Parenthood?
That was 1991, as I recall, early 90s.
Okay.
And what the Supreme Court in Casey clarified Roe v. Wade is that the right to choose prior to viability is subject to very limited restrictions or burdens. Post-viability, the state has a compelling interest in the life of the fetus, not complete, but a compelling state interest. Fast forward to 2016, as you just said, McGraw, the court has again reaffirmed the right to an abortion announced in Roe v. Wade, but it has clarified its ruling in Casey in the early 90s as to the burdens that can be placed on the woman's right to choose, and then the sort of the framework with which to analyze whether the health benefits for women that Texas thought they were doing, whether those health benefits are enough.
So does this mean it's going to be another 20 years before they take another abortion case?
I think it's highly unlikely that you will see in the next certainly several years another significant abortion case. Rather, there will be, as I said a moment ago, a lot of litigation, McGraw, in the various federal courts across the country litigating what the court held yesterday in the Texas case.
Do we take anything? Yesterday you taught us that the 4-4 tie, and you reading the tea leaves, you thought they tried to sort of sway one or the other. Is there any evidence that they tried to, it was 4-4 and they tried to sway one or the other by not having the senior justice write the opinion?
I don't think so, McGraw, and again, we'll never know.
Right.
But Justice Kennedy, he was very directly involved in the Casey opinion.
Right.
So the fact that Justice Kennedy sided as part of the five, I think intellectually is consistent with his holding in Casey. So my guess is that the vote at the conference that week after oral argument was 5-3. And Justice Kennedy assigned the case to Justice Breyer to write the opinion. What I think is interesting is we talked last week about the 4-4 that you just mentioned. Had it been 4-4, then the ruling of the Fifth Circuit, which blocked the district court, and the Fifth Circuit, in effect, allowed these restrictions to go forward. Well, we would have awakened today with the restrictions in place in Texas, and more importantly, there would not be this national precedent that was set yesterday by the decision of the 5-3.
So the cacophony of noise rested on Kennedy's voting for or against.
It turned on the vote of one justice of the United States Supreme Court. Had he voted with the 4, then the restrictions in Texas would be in effect today, but in the rest of the country there would not be a rule of law. He voted to make it 5-3. The Texas restrictions are out, and now there is a rule that is binding on the other states.
Okay, 2 more rulings yesterday that were quite interesting. One was the Maine ruling saying that if a state says if you are convicted of domestic violence, you cannot carry a gun or purchase a gun. That was upheld. That state's right was upheld yesterday.
I characterize it a little differently.
Right. That's why you're here.
Tony Messenger was on before, and
Yeah.
I enjoyed the passion with which Tony was talking about the issue. But I think
He was wrong.
as to what Governor Nixon did with his veto and what the Supreme
Right.
Court, little different. Let me
Okay.
see if I can break down the Supreme Court piece.
Please.
There has been a statute, criminal statute, on the books that, as a matter of federal law, it is a crime for a convicted felon to possess a firearm.
Right.
And that federal statute defines what the triggering felony is to then trigger this statute that you can't possess a firearm if you've been convicted of that. The question was whether a conviction for domestic violence at a state level qualified as a felony for the federal criminal statute, which prohibits you from possessing a firearm. There was a statute in Maine. The individual in Maine had been convicted of a crime of domestic violence and was subsequently then found with a weapon. Did he violate the federal statute prohibiting felons from owning a weapon? What the court held yesterday was the Maine domestic violence statute under which he was convicted. It qualified as a felony under the felony gun statute, and therefore he was guilty of felony gun possession as a matter of federal law.
And what was that vote? It was 6-2.
I think it was 6-2, but it was, again, I think we need to be careful in terms of as comparing to this decision with the Texas abortion statute. This was a very narrow decision interpreting a very narrow federal statute.
Gotcha.
It is not, let's be clear, McGraw, it is not, and yesterday had nothing to do with the Second Amendment.
Right. So it was super inside baseball, obscure statute versus obscure statute.
You should be a law professor, my friend. Well put.
Yeah, I could use the pay raise. And then they were united in this corruption case, which I am still trying to figure all this out. Explain this one.
Goodness gracious. Well, the former governor of Virginia and Governor Robert McDonnell and his wife, while he was a sitting governor and she was the first lady of Virginia, took approximately $175,000 in gifts from a Mr. Williams,
Yes.
including a Rolex watch, $15,000 for catering their daughter's wedding reception, a $50,000 shopping spree in New York, and riding in his Ferrari. The governor and his wife both were indicted, tried, and convicted and sentenced under federal corruption statutes.
Right.
And it went to the Supreme Court yesterday, and the Supreme Court yesterday, 8-0, reversed Governor McDonnell's conviction and remanded it back to the federal court in Virginia for a new trial on whether he violated the federal corruption statute.
Because what he did wasn't corrupt. What did they overturn it on?
Again, back to the main case. A lot of inside baseball. What it turned on was interpretation of the federal corruption statute, which requires a quid and a quo, a quid pro quo, as to government action. So if you're the governor, McGraw, and I say, here's $1 million, you need to issue this executive order to do X, Y, and Z.
Right.
And you do, and we agree to that.
Right.
You and I have violated the federal bribery statute.
Yeah.
If I give you $1 million and you say, you know what, we're having a big town hall meeting in Clayton next week. I want you to sit in the front row. Is that a violation of the federal corruption statute? The Supreme Court yesterday said no. That in and of itself is not enough action to constitute bribery.
Wow.
Yeah. So, but to be clear, I think Justice Roberts, they do not have, he and his colleagues on the court, they don't have a tin ear to the body politic. And he, at the end of his opinion, I think spoke volumes as to what he and his fellow 7 justices felt about what McDonnell had done. And what he said was, quote, "This case is distasteful. It may be worse than that. But our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. It is instead with the broader implications of the federal bribery statute, unquote. I think Chief Justice Roberts and the other 7 justices were sickened by, as he says, the tawdry behavior.
But the law being the law, they could only rule on what the law says, and he didn't go that far.
Well, a jury will decide on the retrial whether he went that far to have agreed to an action.
Gotcha.
But to invite people to meetings or to suggest phone calls, what they held is that in and of itself was not enough.
Last question for you, Greg Willard. Another great couple of credits we earned towards our degree as a law student at St. Louis University. They have the flair for the dramatic, right? They release it on a Monday. They don't release it on a Friday. And they save the most influential, most powerful, most entertaining, most noteworthy cases till the end. So they do kind of play the PR game, even though it's cloaked in secrecy and we'll never know. They also play that PR game.
Well, perhaps. I don't think so.
All right.
I think what you see in the Texas case is a very good example, McGraw, is it was a very tough case, a very divisive case, even among the justices. You read Justice Thomas and Justice Alito, their respective dissents. Wow. You can hear the sizzle. They were so upset.
Right.
The totality of the opinions was 107 pages. So I think more likely than sort of having a public relations flourish at the end of their term, I think the reality probably was they were struggling mightily to complete their opinions, complete their decisions before the term ended, and that's why the Texas decision came out when it did.
Certainly interesting stuff. Gerald Ford, your old boss, Republican president, he was pro-choice, was he not?
Not in the traditional sense. Mrs. Ford certainly was. But President Ford, I think, had a more balanced or a more nuanced view than some. But Mrs. Ford was very pro-Roe v. Wade.
It was also kind of pre this pro-life, pro-choice fight, right? I mean, he was sort of...
Well, Roe v. Wade was 73, and so he became president in 74.
Right.
And the virulence in the public square had not reached and the passion had not reached some of the levels that it has in the decades since.
Right. Interesting stuff. Greg Willard. Now get back to school. Thank you very much for checking in.
Always good to be with you, my friend.
Professor Greg Willard, St. Louis University law professor as well as KTRS legal analyst. That was fascinating stuff. 927, Big 550, KTRS.
This is McGraw Live on KPLR 11.2, STLtoday.com, and the Big 550 KTRS.
Oh, my goodness.
Here we go. St. Louis summer is here. Now is the best time to call Premier Heating and Cooling to make sure your air conditioner is ready for the season. Ask about the maintenance agreements. In fact, purchase a new American Standard heating and air conditioning system and receive up to $1,100 rebate or 0% APR for 36 months. Premier Heating and Cooling has over 25 years experience in residential and commercial HVAC. It is a family-owned business, and they work on all brands and all types of heating and cooling equipment. And besides
McGraw.
Properly, do you suffer from allergies? They take care of your indoor air quality as well. So give Premier Heating and Cooling.
Does he want to take any phone calls? They're not. They're just kind of weird. But there are people that are calling it. I know that we have.
We got the 940
I
just
guess
too.
940. So
916-1122.
Celebrate America's birthday with America's favorite pastime.
and it's not a great phone call.
What do they want to talk about?
I mean, I could barely make out because but he wanted to talk about the governor and the Supreme Court ruling in that particular case. And then Tom, the weirdo from Troy, wanted to know if you'd still feel the same way about the governor if he was a Democrat. A Democrat.
What about which?
The governor of Virginia?
Oh, would I feel the same way that he got hosed? Or that...
If he was a Democrat?
Would I feel the same way?
Yes.
I don't understand that.
Well, like I said, they're not great phone calls, but there are some phone calls. Well, there's at least one. You've got a 940, though, and you don't have a lot of time here.
This is Whitey Herzog with Holper's Pest and Animal Solutions with my good friend Jeff Holper. I've known Jeff for 25 years, and he's taking
we'll
my
take
yard.
We'll take that
all
Tom
the
guy.
pests around.
It's not Tom. This one's Art. But once you take one phone call, he'll probably call back.
Okay.
Because he's weird like that.
All right. Have you found that audio yet? Okay.
That's 314-544-PEST.
Hello, Jay Randolph here for my friends at Broadway Ford Truck Sales. And here is Terry, the Vice President of Sales.
Thanks, Jay. Here at Broadway Ford Truck Sales, your business preferred network dealer, we offer a variety of financing options to get you in a new or used vehicle to get your job done right. We have been in the same location for over 50 years. We must be doing something right.
Broadway Ford Truck Sales is located at 1506 South 7th Street in the Soulard Market area. On
Here we go.
truck.com.